Hi, Caitlin.
Good morning.
Can you let me know, are you Caitlin Donnelly?
Yes,
Did I pronounce that properly?
yes, thank you.
Okay, great. So for a while, I'll just keep any participants your camera and your sound off. And when we call your case, then you can turn your camera and microphone on.
Okay,
Thank you.
thank you.
Hi, Commissioner Whitworth. Hi, Commissioner O'Brien. Hi, Commissioner Ashby. Now we have a quorum. Excellent. There she is.
I still have 3 minutes. I was up and moving.
Just checking.
I don't know why you think I might have slept through this.
Yes, for the future recording. Barbara is in California, so it's 5 a.m. there. She is a champion among men. Yes. Yeah, sure. Just go with it.
I wonder why only the men admire me.
You're a champion among people. Is that better? Yeah.
Also, for the future recording, I routinely stick out my tongue.
That's a known fact.
Good morning, Barbara.
Morning, Deb.
Last time we could say that.
Nope, I'm going to stalk her.
I've been stalked, as you can well imagine, in my profession.
Oh, I'm gonna hurl.
Please don't. But your microphone is
Sorry,
on.
forgot.
Yep, microphone
Forgot
on.
I wasn't muted.
Hi, Commissioner David. Nope, couldn't hear you, but I think you said hi.
I did say hi, thank you.
Virginia, are you Miss Barrows?
Yes, I am.
Okay, just so you know, I'll keep you muted until your case is called for hearing.
Sure.
And Mr. Noyes, I see you. I will keep you muted as well until it's time for your case to be heard. Thank you. Apparently I can't mute you, which is interesting.
I have 8:30, so let's get this meeting started. Good morning, everybody. I'm Deb Whitworth, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they're silenced now. You've received an agenda along with the notice of today's meeting, including the consent agenda. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. We will vote on those cases shortly, and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. The commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Before we hear our cases, we would first like to adopt the agenda and consent agenda. Is there a motion?
I move that we adopt the agenda and the consent agenda.
Second,
So because we are meeting remotely, we are following remote meeting protocols, which means that for every single vote, I have to poll every single commissioner and I need to see and hear all your votes. So I need you to signify your vote with a visual, but also to say your vote. So the motion is to adopt the agenda and consent agenda. If you say yes, you're in favor. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Thank you.
And minutes of the July 2022 commission meeting. Is there a motion to accept or amend those minutes?
I move we adopt the minutes of the July 22nd meeting.
Second.
So the motion is to adopt July 2022 meeting minutes. If you say yes, you're in agreement. Commissioner Whitworth,
I'll abstain. I wasn't at that meeting.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
I forgot to ask if there was discussion both times. Apologies, I'm gonna remember as we go. Was there any discussion on either motion? No, okay, thank you. I'm gonna get better. So, sorry, Commissioner Whitworth, go ahead.
Amy, if we could have a director's report, please.
Yes, so good morning, commissioners. Pretty light on the director's report today. You have a memo from me noting the status of our personnel. So I probably will jinx us by saying this, but this is the first time in years that we are fully staffed, which is very exciting. I'm Barbara's shaking her head because I probably have just cursed us, but we have on here today our newest investigator, Colin Hurd, who I told I was going, there he is. Hi, Colin. And so next is the status of pending reasonable grounds cases. You have a memo from Jane O'Reilly showing that since the last meeting, there were no successful conciliations. There were 2 unsuccessful conciliations, and there's 1 reasonable grounds case. Oh no, 2 cases that are actively being conciliated. For investigation, I believe you have a nice report that Mel put together. We still have not been terribly successful in getting EEOC's new system to spit out reports in the way that we're used to, but Mel is forcing it to cooperate. So in July, we had 29 new complaints filed. I administratively dismissed 17 cases. And for predetermination settlements or withdrawals with benefits, we had 7 in July with benefits of about $140,000 to complainants.
Amy,
Yes.
do you know just roughly, without trying to compute it, how the 29 stacks up month to month and how we are year to date?
That's a great question. 29 is actually a little low. Usually we're between 30 and 40 a month. I don't have a number yet for this year, but I believe we are at least about average, if not higher. One of the things that we really count on the EEOC system for, unfortunately, is tabulating year-to-year data for us. So we can get some numbers out of our internal system, but in order to compare apples to apples, we really need the EEOC system. And Mel is actually such an expert user of their systems that they actually had Mel consulting with them to help develop their reports. So we're going to be creating an annual report of some type. It's going to have as much data as we can squeeze out of the EEOC system. But I hope to be able to get you a better, more complete answer to that, Ed.
Thanks.
Litigation, I would ask that we take after executive session. And for new business, first and foremost, today is Commissioner Deb Whitworth's last meeting. And she would not let me do a big thing, but I'm doing a thing because I'm really sad. And she's been an amazing commissioner for over 10 years. She was on the panel of commissioners who hired me. And she has been a stalwart, dedicated member of our commission for over probably 11 years now, at least, appointed by governors from both parties and just been an outstanding acting chair as well as commissioner. And I just want to thank you. I rarely attempt to speak for the people of Maine, and I won't do so here, but on behalf of the commission staff, we are so grateful for your work and leadership, Deb, and showing up meeting after meeting for such a long time. So thank you.
You're welcome, and it has been an honor.
So that's the first piece of new business.
Here, here.
Here, here.
Yeah.
Thank you.
Deb, make it 11, please.
I think her term technically ended at the beginning of the month, so she's kind of doing us a favor now. Jeff, I see your message. I will figure out how to get that to you. Other new business, Barbara is at a national meeting of the International Association of Official Human Rights Agencies. It's a tough acronym, IORA, in LA. Yeah, so she's representing Maine out there. It's gone as far as she can go. But she was extremely busy putting out reports before she left, her and Kit both, but also putting our rule proposals, 3 out of the 4 rule proposals out for public comment. So they are out. I think you all got a copy, commissioners, by email. They're on our website. We sent them out to the attorneys who frequently practice before us, and they are published, which is a required part of the process in the legal journals where those things happen. And I believe comments are due September 6th. And the only other piece of new business is that we internally are preparing budget proposals for the next biennium. So the 2023 to 2025 budget cycle, as well as a supplemental for this 22-23 year. So we'll be busy with that, or Mel will be busy with that at the same time that she's trying to squeeze data out of the EEOC system. So that's what I have for new business. Unless there's anything else from commissioners for new business. I think we have 6 minutes.
So we'll be back at 8:45.
Thank you.
Thank you all.
Amy,
Yes, I just sent you an email.
that didn't do the trick.
It didn't?
Nope,
Still missing a page.
same problem.
All right, let me look. 2, 3, 4. It shows page 4 for me. The one I just sent you shows page 4.
It's page 5.
Page
we need.
5.
And it goes, what you just sent goes from 4 to 6.
Really? All right, I'm looking. 2, 3, 4. Yes, yes, I see that now. Yep. I do see that. Hold on. I'm gonna go into the drive and see if I can find it. I think whatever got uploaded did not upload with all the pages. Hold on. Maybe I can get it here. I really hope this is it. 2. That has multiple missing pages. Huh. Wait.
Yeah, I concur that they're missing.
Yep. 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 I see that. Hold on. Why don't we hold on. I think we should hear the second and third cases so that commissioners have time to digest once we get that sent. Yes, I agree with you, Commissioner Ashby. We should table it for a moment until I can get you guys a version of the report that has all the pages. I'm just trying to find one. So for folks who are on here, I'm going to ask that we table the noise case for a few minutes while we get the commissioners a copy of something that they don't have. Oh, Mr. Schmitz, that is very kind of you. Do you have all the pages in there, Ryan? Ryan Schmitz has said he will be happy to send us the copy, which is great because we don't appear to have it in our drive. Thank you very much, Ryan. If you can send it to me, I will send it to the commissioners. Thank you so much.
Okay, it's 8:45. Are we ready? Okay.
Yep.
So cases will not be called in order on the accepted agenda. We will start with our second case. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. The time is limited to 10 minutes. Time may be reserved to rebut opposing arguments, but the time limit of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only number 1, relevant factual errors, number 2, relevant omissions from the report of facts submitted during the investigation, or 3, relevant issues and questions concerning interpretation of the law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposite party. Please be advised that commissioners may ask questions. I will ask you to introduce yourself as you are called to present your case. Thank you. Our first case now is E20-0428, Caitlin Doney v. TD Bank. Is there anybody here for the complainant?
Good morning. Attorney Michael Verasso for the complainant.
Go ahead, Mr. Barrasso.
Good morning. Thank you, commissioners. At the outset, our request for a reconsideration or request for an overturning of the current report is based on a few different factors, but the most obvious factor and the most obvious inaccuracy in the report is that the report explicitly refuses to consider certain documents and explicitly makes factual claims that are just unsupported by documents that the investigator had in their possession. In fact, were provided even in the respondent's position statement. For example, the investigator explicitly refuses to discuss and explicitly notes that they are refusing to discuss Ms. Donnell's request for accommodation, that they are not considering her request to work from home as connected to her disability, that the request to work from home was not disability related. And they note this on page 1, footnote 2, that they are just not going to be considering them. In fact, they say, complainant alleged she was denied a reasonable accommodation because she was not permitted to work from home. Complainant stated she made 2 requests that were both denied. And it goes on to say, this is not a disability-related request. At the outset, the investigator concedes that Ms. Donnell had testified under oath, had provided information on her own testimony that this was a request for an accommodation, that she had requested this as an accommodation, had connected it to her disability. But the investigator still claims that there's no evidence of that. Even if it was proper for the investigator to wholesale disregard Ms. Donnell's testimony and refuse to provide it any weight whatsoever, which is improper, it's simply not true. And it disregards contemporaneous documents that both the respondent had at that time and that the investigator himself had during the investigative process. And we provided copies of those for the commission's ease and convenience, but Ms. Donnell had provided medical records. She had provided medical notes supporting her request to work from home. In one of those records that we provided, and which I tried to helpfully highlight the exact point, there's an explicit note in there. At this point, Ms. Donnell is not ready to return to work. However, after a follow-up in 2 weeks, I would recommend that we return her to work in a home office and hold off at this point from returning her to the call center. There is a capability for her to be able to work from home after she attends the 1-hour home training class at her work. So the reality is that it's inarguable, really, that Ms. Donnell was requesting the ability to work from home. And it's inarguable that she was connecting this to her disability. And it's also inarguable that there was contemporaneous proof of that, and that the respondent, TD Bank, was aware of this, as they were the ones who even provided the documents to the commission, explicitly noting, yes, this is a reasonable accommodation request for a disability-related reason to work from home. And despite that, despite the fact that all of those records were properly before the commission, and in fact had been there since the position statement was received early on in the case, the investigator explicitly notes her claim of denial of a reasonable accommodation fails and will not be analyzed further in this report. It also notes that the same thing takes place for her hostile work environment claim, because they say that there weren't any accommodations, there weren't any evidence of that. But again, all of those things are supported in the record by contemporaneous documents. The other significant issue that is glossed over by the report is that at the end of the day, there is a very clear-cut timeline. And the respondent consistently points to this one email in April saying, oh, well, we had first mentioned wanting to terminate her back then. But the reality is that the respondent never provided, and it was seemingly never requested to provide, any responses to that email, any follow-up to that email, any indication of how the respondent analyzed that. Because what is clear is that the decision to terminate was not made at that point. And in fact, doesn't even seem to have been discussed internally at that point. There's one email saying, we would like to discuss termination at this point. They then drop it. They don't discuss it any further. There's no analysis of it. And instead, when the complainant returns to work and requests to work from home, they respond to the request to work from home by saying, well, look, if she wants to work from home, we don't want to allow that, and we think we should terminate her instead. This is in the respondent's contemporaneous notes. This is their own document, their own contemporaneous timeline of events that they set forth exactly what is occurring. May 1st, 2020, the complainant requests to be able to work from home. Their first response to that is to say, okay, well, let's analyze this. And then on May 4th, they reach a decision. And that decision is Madden does not want Ms. Donald to work from home due to the risk to the business. Calls cannot be monitored and Donald's recent behavior. And then they explicitly, in their own documents, say, well, if she's requesting to work from home, if she is trying to work from home, rather than let her work from home, we'd rather fire her. And the investigator just ignores that timeline and says, well, they had in an email in April mentioned that they might want to fire her then. But there's no follow-up to that email. There's no request to how that decision was actually made or investigated at that point. And the respondents' emails that they did provide about that just end. They make the statement, oh, we would like to consider the termination in April, and then it's indisputable. They don't fire her then. They don't finalize the decision then. They don't do anything in response to that April email at that point. And so at the very least, we're not sitting here saying, well, there should be an automatic finding against the respondent, or there should be a verdict awarded against the respondent. But at the very least, all of these documents, all of these facts make it very clear that there is more than enough for probable cause, that there are significant questions raised that should be determined ultimately at a public hearing before a fact finder. And that's what is at issue here. And for those reasons, some of which are just factual inaccuracies in the report, some of which are just logical leaps in the report that are unsupported, we do request that the report not be entered into as a no probable cause finding, that the commissioners not endorse it. And I would reserve the rest of my time. I see Attorney Bingham is here for any response to Attorney Bingham.
Thank you. And before we go to that, I would ask if commissioners have any questions for Mr. Barrasso so far. If you do, raise your hand and I will call on each of you in order of seniority on the commission. Commissioner Ashby.
Yeah, I have a question about whether or not the complainant was cleared to return to work without restriction in May. That seems to be what footnote 2 says. In May of 2020, complainant was cleared to return to work without restriction. I'm aware that the complainant's position is that she has an April 16 note that says she should be permitted to ease into work by starting at home, but it seems, at least in this footnote, and I'm not sure if it's discussed anywhere else, that she was cleared without restriction when she did in fact return in May.
Well, Thank you for your question, Commissioner. I don't read footnote 2 in the same way as you. I think in footnote 2, it explicitly notes this was not a disability-related request. In May of 2020, complainant was cleared to return to work without restriction. Complainant requested to return to work from home when she returned, but she did not tie this request to her disability, and her paperwork did not support that she was requesting any additional accommodations when she returned to work. That is simply untrue. The paperwork does explicitly note that allowing her to return to work in a remote capacity would be good for her disability, would be an accommodation for her disability. I think at the end of the day, Miss Donnell could have, if push came to shove, soldiered on and toughened out and worked in an in-person capacity, but that was not and is not the legal requirement ever for this situation. Miss Donnell was requesting the accommodation of returning to work in a remote capacity due to her disability. The respondent would have been within their rights to engage in an interactive dialogue about it, would have been within their rights to deny it if they wanted to and say, okay, well, you can come back and work from the office, or let's engage in a dialogue about it. Let's see how it plays out for a week, 2 weeks, etc. But what the respondent did in this situation is instead refuse to have a conversation with Ms. Donnell, receive her request, fail to consider any other alternatives, and say, well, if she wants to work from home, we would rather fire her.
Thank you. Secondly, you have suggested that in April, specifically it's April 6th, that emails were exchanged to discuss the claimant's employment. You've suggested that it was only suggested that termination was on the table, but I read, am I correct, in the respondent's response to your appeal, they quote the email. It says, escalate through HR seeking termination based on her previous, I assume it's probation, maybe PROB, WW for similar conduct. Is that a verbatim of that? Did the respondent accurately reproduce the relevant portion of that email?
Yes, I mean, that is an accurate request for a termination. But like I noted in my original statement, there's no follow-up. It doesn't actually go anywhere. HR never seemingly approves that termination.
I guess, is there some sort of mechanism that ordinarily is followed that isn't followed in this case? You said they never approved it. I guess there's no evidence in the record that I can see as to whether or not a certain process needed to be followed. My understanding from this investigator's report is that the decision to terminate was made on April 6th. The request for accommodation was made sometime after that, but it wasn't discussed with the employee because the employee wasn't physically present to discuss it until she returned. Are you suggesting that there was an additional step that needed to be taken by the employer in this case that wasn't taken?
Well, what we're suggesting is that it's very clear that the decision was not made in April and was not made around April 6th. Because if the decision to terminate was made in April 6th, when you see the May 1st reasonable accommodation request come in, there wouldn't be a dialogue internally at the respondent saying, okay, well, let's consider this. Let's have a meeting to discuss her accommodation request. Let's go through this. Their immediate response to it would not be, we would rather not have her work from home due to prior behavior. Let's discuss how we want to handle her request to work from home, followed up by 3 days later saying, actually, let's just fire her instead. If they had already fired her on April 6th, a month before, she would have requested to work from home on May 1st, and they would have internally at minimum said, well, we don't really need to have a conversation about this because we fired her already, so we're not letting her to return to work, either remotely or in person. But they, in fact, do bring her back in person for a day. They, in fact, do have 4 days of consideration about this request to work from home. And so what is our position and what we're calling into question and what does not appear to have been considered is that, yes, there is this April 6th request for termination, but the respondent never actually provides any evidence as to what was done with that request, whether HR approved it or rejected it, which seems likely given that in May, after an accommodation request comes in, the response isn't, oh, well, we actually have already fired the complainant, so it doesn't actually matter whether she wants to work remotely or not. Instead, the decision is, let's have a meeting about her request. We don't think she, the complainant, can work from home. Rather than discuss any alternatives, how about we fire her now? A month after this, where the respondent says, oh, we had already fired her back in April.
You are ascribing or paraphrasing what's present, though. There's nothing in the record that says that the respondent said, oh, let's consider it, but rather than give her an accommodation, let's just fire her instead. You agree that the record really doesn't say anything like that, correct?
No, I think the record does say that.
I have no further questions. Thank you.
Commissioner David and then Commissioner Whitworth.
Yeah, Attorney Verasso, do you agree that it's irrelevant that her behavior, the verbal behavior, is a relevant consideration in terms of whether or not she could be allowed to work from home because she can't be monitored? Hasn't she put her own ability to deal with customers and supervisors and stuff at issue by that behavior, such that that's a relevant consideration?
Well, of course, I think the respondent would be well within their rights to consider that. Obviously, we do dispute that behavior, and that was disputed throughout the proceeding, but that's not relevant to what the commission is finding today or is including in its decision. At the end of the day, the respondent is allowed to consider those things, and they could weigh those when deciding to grant or deny her reasonable accommodation request.
Well, is your legal position, well, let me put it this way. Would you agree, would you take the position that a disciplinary firing for disciplinary reasons could trump the disability claim? Can't they fire her anyway? And I guess respond to that. You know, your entire presentation didn't mention anything at all about the behavior, which is the elephant in the room. Aren't they entitled to fire her for that kind of behavior towards supervisors? You
Well,
say you say you dispute it, but that's a disputation of a factual issue. But if that's found, isn't that a justification for firing her?
Of course, Commissioner. And yes, under the law, the respondent can fire somebody for any reason. It doesn't even need to be behavior reason whatsoever. But that's not what the facts show. The facts in this case are very clear, and most of them are not in dispute. The alleged behavior incident occurs in April. There is an email requesting a termination to HR that, based on the clear timeline, does not appear to have been done. It does not appear to be implemented. HR does not appear to have approved it. There is no response from HR saying, yes, actually, we do approve this termination. Nothing further happens. Ms. Donnell requests the accommodation of working from home due to her disability. On May 1st, they have a meeting about this, or May 4th, they have a meeting about this. During that meeting, Madden takes the position explicitly in their notes that he does not want her to work from home. And then the second thing he says in that, according to their own notes, is that he now wants to move forward with termination. He reiterates his request for termination, which then at that point seemingly gets approved. But it was not approved. Clearly on the record, it is not approved prior to her requesting to work from home, prior to her requesting the accommodation.
Mr.
And
Verasso,
so
I'm sorry to interrupt you. I should have done it before, but you've twice mentioned the name of someone who's perhaps a supervisor, but who's not a named party in the case. And I should have said this at the beginning to remind all people here not to mention the names of third parties. We've given them pseudonyms in reports. So I apologize for getting in the middle of your stream of thought, but
Sure,
please don't
my
mention the name again.
apologies. Obviously, certainly not intentional. The decision maker at issue then makes the request again, and then it appears that over the next 3 days until May 7th, that request is considered internally, and ultimately, yes, they say, okay, well, we'll move forward with the termination of the complainant. But based on the April 6th email and the chain of that timeline, it's very clear that that first request having been made in April was not approved. It was not agreed on. There was not a decision at that point to terminate the complainant. It only became approved. They only decided, okay, we're going to approve the termination after the complainant requests to work from home. And that does raise the question of, okay, well, what changed? And in those situations, in that situation, when you isolate it down, what changed is very simple. The complainant requested an accommodation, and that is an illegal motivation.
My last question, back to that footnote 2, it says that her initial request to take time off from work was to take care of children. Is that not the case? That was what she stated as the reason?
We've been very upfront. Yes, her initial request in March to work from home was to take care of her children.
Okay, and it's part of the social trauma of the pandemic that people are in this situation, and we're trying to adjust the unemployment rights and all of those kinds of things. But you do agree that that's not a demand for that's not a disability needing to take care of children.
Well, of course, we agree that the one in March we're not asserting was disability related. We're asserting the one in May, which was explicitly due to her anxiety disability flaring up as a result of the pandemic, as a result of how unsafe complainant felt leaving her house, how she felt like she needed to consistently be double masked, washing her hands constantly, changing her clothes consistently because of her anxiety disability. The one in May is both very explicitly from complainant tied to her disability and from the medical records that were provided to respondent and provided to the commission are explicitly tied to her disability.
Thank you.
You're welcome, Commissioner.
Commissioner Whitworth, did you have a question?
I think this might be more for Barbara. Barbara, does an employer have an obligation to consider a remote work request as part of a disability accommodation?
To consider it if it's connected to a disability, yes, working from home could be a reasonable accommodation.
However, an employer can say that that's an undue hardship based on the job description.
They certainly can, or that it's unreasonable under the circumstances. There are many reasons that it could be denied, but still have been considered.
Thank you.
Any additional questions from commissioners at this time? Mr. Barrasso has about a minute left when we come back to you. So at this time, we'll turn to Mr. Bingham.
Thank you, commissioners. I'd just like to start with the timeline here, and in TD Bank's view, obviously in my view, this timeline really reflects HR best practices for how to handle a situation like this. We've described the conduct that needed to be responded to. And it wasn't just a casual profanity in the workplace. It was really a 2-day long tirade. It was completely inappropriate. She used several obscenities directed towards different managers. She accused the manager of gaslighting her. It's all in the record, so I won't repeat it. But it was serious conduct. Ms. Donald then took a leave of absence. And Mr. Barrasso didn't point out that TD Bank granted that leave of absence. They accommodated her. Now he's focusing on a different one, but they accommodated this one, essentially a 1 month leave to handle whatever situation, whether it was child related, whether it was, they accommodated her. So that's not really in dispute. When she's out on the leave of absence, and it's protected time off. They can't act on Mr. Madden's request to
Again,
terminate.
I'm sorry, Mr. Bingham. Again, I need to
I'm
ask you
sorry.
not to use the names. Thank you. As I know it's hard to keep that in mind for everyone.
I told myself I'd do it, but they can't act on the call center manager's request terminate at that time. It's not a good practice, and here's why. You'd have to get her on the phone. You'd have to have her come in for a meeting. It's really good practice. So before you fire somebody for misconduct, to get their side of the story. And Mr. Barrasso would skewer me, rightly so, if they fired her without her getting her side of the story, because it would look like they weren't interested in her side of the story, right? So she comes back. So Mr. Barrasso asked, what changed? Here's what changed. Came back to work. They sat her down on the 4th of May. They asked her what happened, her side of the story. They concluded that she had done something seriously wrong, and the call center manager's request, it was a probationary, escalate through, we have the language in the response, but escalate through HR seeking termination based on misconduct and previous probationary, warning for misconduct. So Ms. Donnell had been on a previous warning for unprofessional conduct in the workplace. This really escalated things seriously. So they also have in front of them at the time, May 4th, a request for Ms. Donnell to work from home. Whether it's disability related or not, it did become moot because that request and her previous request for an accommodation didn't somehow give her I think the courts talk about a cloak of invincibility or something like that. I don't know, I'm probably butchering it, but they didn't protect her from the consequences of her actions. And you see the April 6th email is important in that respect because it shows the call center manager's mindset at the time. Of course, there was no decision made at the time because they needed to get her back in the office and see and get her side of the story. They did that. And the call center manager's concern about working from home was very well grounded because Ms. Donnell had engaged in this conduct, and he was concerned that how are we going to monitor folks? How are we going to monitor her? How do we know that she's going to be, she's getting on the phone with customers, that she's going to behave appropriately? So he was concerned about that, but it did become moot because the conduct, as the April 6th email shows, was a terminable offense in the call center manager's mind. And that really is all in the record. And so I would say I think this is a sort of what you want to see in this case. And with respect to the work from home request, Mr. Barrasso is really mischaracterizing how instead they decided to terminate. That's not what happened. You had, everybody remembers at this time, you had thousands of people across the bank, and in the call center in Auburn alone, we put it in, I don't know the number, but it was hundreds. There's a huge transition to work from home. I was doing the same thing as an attorney at the time, and so this idea that they would retaliate against her for requesting to work from home really doesn't really hold water because a ton of people work from home. It was not a big deal. Nothing about it was disability related. It was to prevent a deadly disease from spreading. That's the timeline. I really would rely mostly on our response to, in other respects, and I'd be happy to answer any questions. Everything I think in the record is very well supported, and we think the decision should be affirmed.
Thank you, Mr. Bingham. Hold on 1 second. I need to write down how much time is left before I forget. Any commissioner questions for Mr. Bingham at this time? If so, just raise your hand and I'll call on you in order of seniority or whoever's hand I see first. I do not see any commissioner hands at the moment. Mr. Bingham, you'll have about 4.5 minutes left. So at this time, we'll turn back to Mr. Verasso. Mr. Verasso, you have about a minute.
Thank you. Attorney Bingham is a very good attorney. I've worked with him frequently opposite aisles. Repeatedly highlights, okay, well, we wanted to get her side of the story, and I would skewer him if we didn't get her side of the story. And it's right, of course we would. That's exactly a good argument for the plaintiff. The reality, though, is Ms. Donald's leave ended April 30th. That's undisputed. That's also throughout the record as well. It wasn't until after the request for accommodation that the termination decision became requested or reiterated and affirmed. That is just the explicit timeline. That is not a distortion of the facts. That is not selective highlighting of the facts. It is the reality of the situation. It is the objective showing of the information.
Mr. Verasso, that's your time. Okay. Any commissioner questions for Mr. Verasso at this point? If so, just raise your hand. Not, oh, yep, Commissioner David.
The attached exhibits, I'm not sure who attached those exhibits. Is that exhibit 1? Is that are you attaching the medical justification for the request for accommodation?
Commissioner, for my clarity purposes, so I'm not giving you the wrong answer, which attached exhibits? The ones to our request for
That's right.
the appeal? Yes, we would have attached those, but those were initially provided to the commission by the respondent.
No, but you attached them as part of your presentation.
Yes, Commissioner.
Yeah. Okay. Thank you. That's all.
Any other commissioner questions for Mr. Verasso? Seeing none. Thank you for Mr. Verasso. Mr. Bingham, you have about 4.5 minutes left.
Thank you, Director Sneerson. I don't have anything to add at this time.
Okay. Any commissioner follow-up for Mr. Bingham?
Well,
yeah, Commissioner David.
yes, I neglected to ask you before. I believe that you say at the end of the day, in this case, that except for the verbal attacks and behavior and the discipline that they felt was necessary for that, they would not have terminated her. Is that correct?
Well, that is correct. Yes.
Yeah.
That's the reason for termination. Yes.
Yeah. Okay. Thank you.
Any other questions for Mr. Bingham? Seeing none. Thank you, Mr. Bingham. So then we would turn to the investigator, Jane O'Reilly.
Good morning, commissioners. I'm Jane O'Reilly. I was the investigator on this case. I also just want to apologize. I've been trying to make myself less dark with this window behind me. It's difficult, so I hope you can see me. I'll just defer to your questions on the factual disputes. I just want to comment on a couple of things that Attorney Verasso mentioned in his presentation. One was that complainant made a few statements under oath. The only document we have in our files that is under oath or notarized or anything like that is the complaint form. And I made note of both paragraphs in the complaint form that talk about the reasonable accommodation request, and I'm happy to read them to you if you want, but there is no under oath statement in the complaint form that the requests were reasonable accommodations, or they're made clear that they were reasonable accommodations at the time. So that's part of the information that I used. It certainly was stated in later submissions. I just wanted to make the statement about under oath clear. And also just wanted to reference, since it was discussed, I obviously do consider and review all of the information in the file. I may come to a different conclusion about interpreting that information, but I did look at everything in the file, including the documents that were attached as part of complainant submission. And I'm happy to answer any questions.
Thank you, Jane. Any commissioner questions for the investigator? If so, raise your hand. I see Commissioner David.
Attorney Verasso, good morning, Jane. Attorney Verasso says that they dispute the the allegations of the verbal misconduct. Did you have any question about that? Is there any, I mean, that isn't the, is it the case that that's verified by more than one person from respondent?
So unfortunately, there was the people who were part of the conversation and that was it. However, in order to inform my analysis that it was more likely than not the complainant did engage in the conduct alleged, was the contemporaneous email that was sent afterwards to report the behavior, as well as the comments that were written actually as part of the documents that were attached to complainant's rebuttal to the report, that when she returned from work and they were going to have a meeting with her regarding her work from home request, that they were concerned about it based on prior behavior. So those were the pieces of evidence that I used to establish it was more likely than not that she engaged in that conduct. I also ultimately weigh that against, are there other suggestions that the termination was based on disability? And I couldn't find anything to strongly support that either. So
That's that's very helpful and to the point of my question. My other question is this mention of a previous discipline, is that weigh in heavily? Do you investigate that? Do you know what that is, or does it not matter? Is
not
it part
much.
of their, okay,
Yeah,
not much.
so that prior discipline happened, far enough back that I didn't find it as relevant to the decision they were making now. It certainly appears to have weighed in on their decision about her behavior, but ultimately I found even if it was just the behavior on the one phone call that had happened in April, or sorry, the 2 phone calls that had happened in April, that was sufficient to show that it wasn't a discriminatory motive.
Thank you.
Any other commissioner questions for the investigator? Not seeing any. Okay, thank you, Jane. So commissioners, there's one proposed finding, but it does include both disability and retaliation. So we would be looking for a motion or motions.
I'll move that we find that there's no reasonable grounds to believe that respondent discriminated unlawfully on the basis of disability nor retaliated, and that the complaint should be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds on both disability and retaliation. Is there any discussion among commissioners?
Yeah, it seems to me that disciplinary action is appropriate, that there's no need to stand for that, and that's the end of the day, and that's a justification that makes the rest of it moot.
Any other discussion from commissioners? Seeing none. So the motion is to find no reasonable grounds on both disability and retaliation. If you say yes, you are agreeing with that. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
So the findings on both disability and retaliation are no reasonable grounds. The commission will send the parties and council a letter confirming that later this week. And we thank you for participating in the hearing. Yeah, I was just going to say, Commissioner, I don't know if folks are prepared, commissioners are prepared to hear the noise case next, or if you want to do the Barrows case next.
No, not prepared. I think we need 10 minutes to look at that.
So commissioners, do you want to do the Barrows case?
Yes, let's do Barrows and take a break, if that makes sense.
Is that okay with everyone? Looks like that's okay. Okay, let's do that. And to the noise, the folks who are here for the noise case, I appreciate your patience and apologize again.
So our next case, E20-0535, Virginia Barrows v. Franklin Community Health Network. This is a no reasonable grounds recommendation. Is there anybody here for the claimant?
Ms. Barrows is here. Yep. Can you unmute yourself, Ms. Barrows?
Yes, I'm here.
Oh, wait, your thing shows up as Oh, there you go. Okay. So you have 10 minutes to make your presentation. I'll remind you again, don't use the names of any third parties, okay?
Okay.
Okay.
I apologize for any stuttering because I'm super nervous right now. But I feel like they discriminated against me. Prior to being terminated, there were multiple occasions where not just coworkers in my department, but coworkers in other departments and higher ups in other departments continuously told me that my manager of the patient access department had my back, was obviously looking for ways and reasons to terminate me. In the investigation report, it said that there was some behavior issues. I was unaware of those because nobody brought those up to me. The patient access department did have a lot of changes. It changed every shift at least twice, so that made it unstable to perform to the level that I typically would. If you looked at the emergency department I also worked in, I did not have any negative accounts against me. There was a lack of communication within the department, and the computer system did have some issues on my end, which is what I think is showing, because I did not go into anybody's account, especially the ones that were provided. I would purposely just look at which room they were in so I could avoid their account and that room. And lastly, there's no previous history of me committing any such violations. That's basically it at this point.
Okay. Hold on. Let me just write down a note.
Okay.
So let me see if any commissioners have questions for you at this time. Do any commissioners have questions for Ms. Barrows? Commissioner David?
Yes, Ms. Barrows, one of the allegations, I'm looking at the investigator's report, says that you were reading patient information over the shoulder of a coworker, I think because the patient was a family member, and that the coworker protested. Are you saying that incident flatly did not happen?
I was looking at which room the person was in so I could avoid their account and that particular room. I quite honestly avoided my family and any friends who attended or came to the emergency department. I avoided them like the plague or like COVID or a mix of both.
Well, so as I understand it, your position is flatly denying that you improperly accessed patient records.
Yes.
That never happened, and that's in the face of complaints by at least 2 coworkers, right?
Yes, both coworkers actually wanted the position that I had. So I do feel like they have some vendetta against me. But
I'm sorry, I just have to object. The investigator is telling me that this is not in the record,
Right.
okay.
this information, so we can't talk about anything that the investigator didn't get to consider.
Thank you.
Other questions for Ms. Barrows? So not right at this time. Now, Ms. Barrows, you'll have, I wrote down the wrong thing. You'll have about 7.5 minutes left when we come back to you. If you want to use them, you don't have to. But for now, we're going to turn to the attorney for the hospital, okay? So, all right, Ms. Rand.
Good morning, commissioners. There are factual disputes about certain elements, such as whether Ms. Barrows engaged in protected activity. I'm going to sidestep those issues because the evidence of a non-discriminatory or retaliatory basis for Ms. Barrow's termination is overwhelming. Franklin policy and HIPAA prohibit employees from accessing patient medical records, except when they have a legitimate need to do so. And the record reflected and the information available to Franklin at the time it made this decision included not only the 2 coworker reports that Commissioner David mentioned a moment ago, but also there was evidence, a report was run that showed that Ms. Barrow's login credentials were used to access her family members' medical records at numerous times during the same shift that the coworkers had reported she'd done so. So to prevail on her claim, Ms. Barrows needs to produce some evidence showing that this articulated reason for the termination was pretextual. There are a number of different ways she could do that. She could, for example, have produced evidence that other employees engaged in similar misconduct and didn't experience the same consequence. Not only did she not do that, but Franklin introduced evidence of several other employees who were terminated in or around the same period of time as Ms. Barrows for exactly the same conduct. Alternatively, she could deny that she accessed her family's medical records, and I understand her to be doing that today. However, Ms. Barrow's position on that crucial issue has not been consistent to Franklin at the time or throughout this proceeding. In her September 16th, 2021 submission, for example, Ms. Barrows said she wasn't sure what she was accused of accessing and wrote that if the accounts were accessed, she was either authorized to do so or someone else entered the accounts. And those are 2 inherently inconsistent explanations. She went on in the next paragraph of that submission to admit that she provided human resources with letters from the 2 family members whose medical records she had accessed in violation of the policy. And the investigator correctly noted that retroactive permission, well, first of all, retroactive permission would not be valid under HIPAA. The investigator correctly noted that under the policy, it's really immaterial whether she had her family's permission because there was not a business related reason. In her objection to the investigator's report, she wrote something a little bit different, which was that she would never purposefully commit a violation against anyone's health privacy. So in the 3 submissions, she goes out of her way to avoid answering very directly this question of whether she engaged in this policy violation, though I did hear her to do so here. There's no evidence whatsoever that Franklin terminated her employment for any reason other than this misconduct. And so for that reason, I ask you to adopt the recommendation of the investigator and find no reasonable grounds. And that's all I have for now.
Thank you. Any commissioner questions for Ms. Rand at this time? Not seeing any. In which case you'll have about 6.5 minutes when we come back. So Ms. Barrows, we're going to come back to you. You have 7.5 minutes left. You can use them, you cannot use them, it's up to you.
To be honest, I'm not sure how to use them. I do believe that there was actions against me. I do understand the evidence provided. I also provided my manager with information that apparently did not make it to human resources, and I feel discredited or at a loss for that because I did put in different violations, especially around that time, of other coworkers, and I feel like I'm not being fairly represented from there. I do not know what else to say. In regards to the letters that she mentioned, the family members did receive letters from Franklin and Maine Health. They thought they were doing me a favor of sorts, and I did not know that those letters were submitted until after they were turned into human resources. That is basically all I have. Any questions would be great because I don't know how else to continue.
Thank you. Any commissioner questions for Ms. Barrows? Not seeing any at this time. Thank you. Ms. Rand, you have about 6.5 minutes left if you want to use them.
I just have a clarification, just to make sure the commissioners understand what Ms. Barrows was just referring to. It is true, and I'm quite sure it's in the record that Franklin, when a patient's medical records are accessed in this manner with no legitimate business purpose for doing so, that's a breach for which the hospital is required to notify the patients who are negatively impacted. That's the letter that the family members received from Franklin. And also, I believe it's clear, but in case it isn't, it's Ms. Barrows who provided those letters from her family members to Human Resources. Nothing further.
Thank you. Any commissioner questions for Ms. Rand? Seeing none. Thank you, Ms. Rand. And then we turn to the investigator. It is Jane again.
Hello again. Good morning, commissioners. I don't have anything to add on this case, but I'm happy to answer any questions.
Any commissioner questions for the investigator? Commissioner David? You're muted.
Thank you. Jane, there was reference to evidence of logins from her login password. Do you know the number of those? Multiple?
I believe it was 2. It was provided, and whatever was provided was consistent with what respondent had said happened. So I think it's 2. Let me look.
I thought that was in addition to the one she.
So what had occurred was 2 different employees had reported 2 incidents of logins, and respondent checked and found those 2 logins on the same shift. So twice she had access. It was 2 different, it was a different patient each time, a different family member each time.
But the patient, the patient was a family member each time.
Correct.
Yeah, thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Jane. So commissioners, you have heard from the parties and the investigator. There is one proposed finding, so we would be looking for a motion.
I recommend that we,
Oh,
go ahead, Deb. Go ahead.
I would move to uphold the recommendation of the investigator that there are no reasonable grounds to believe that Franklin Community Health Network retaliated against Virginia Barrows for engaging in WPA protected activity, and the complaint should be dismissed.
Second.
There you go. Okay. So it's been moved and seconded to find no reasonable grounds to believe that there was unlawful whistleblower protected activity. Is there any discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds. If you say yes, you're in agreement with that. Commissioner Whitworth?
Yes.
Commissioner David?
Yes.
Commissioner Ashby?
Yes.
Oh, I skipped you, went in the wrong order. Commissioner O'Brien?
Yes.
So the finding is no reasonable grounds to believe that unlawful retaliation occurred. The commission will send parties and counsel a letter confirming that and outlining procedural next steps. And we thank you for your participation today. So commissioners, did you want to take a 10-minute break? Does that sound right?
Yes.
5 minutes, 10 minutes?
10 is good.
10? Okay. So we'll be back here at 9:50. Thank you. Barbara, you're not here to compete with me for the bathroom. I'm going to go take a leisurely time to stroll to it. I think you said you have your very own, but you're muted. Psych.
Okay, it's 9:50. Are commissioners ready to hear our final case? I don't see Commissioner O'Brien. Okay, then I'll call the meeting back to order. Our final case of the morning is case E20-0320, Kevin Noyes v. City of Portland. There are several recommended findings on this case. Since at least one of them is a reasonable grounds finding, we'll hear from the respondent first. Is Kevin Noyes, I'm sorry, is anybody here for the City of Portland?
Good morning, Commissioners. Antora Grossa for the City of Portland.
Sorry, I was muted. I said, go ahead, you have 10 minutes.
Thank you. Thank you for hearing us today, Commissioners. I know you've only just had a chance to review the full decision, so I will give very briefly just a little context for this. Mr. Noyes does have a disability, including a prosthetic leg, and he had been given extensive leave over the course of about 7 years by the city. He repeatedly exhausted his FMLA leave and was given additional disability leave each time. Finally, in the fall, or I'm sorry, in the summer of 2020, 2019, Mr. Noyes was out again, and he was out for many months, again exhausted his FMLA, and was given several additional months of leave beyond his FMLA entitlement as a reasonable accommodation for his disability. He was ultimately cleared to return to work with a doctor's note stating he had no restrictions and could return to work full duty. At the same time, as he sent in that doctor's note, he also submitted a request for an accommodation for a quote pickup truck. He did not explain in his request for accommodation why he needed a pickup truck, nor give any further explanation about that. The city had given him a doctor's form to complete at that time for to support the ADA request for accommodation, and he never returned that. The city interpreted that request as simply requiring a larger vehicle, which the city gave him. They gave him an SUV. Turns out Mr. Noyes later explained that the need for the larger vehicle was to accommodate fewer knee bends getting in and out of his vehicle. The SUV actually had a higher ground to floor ratio or height than the SUV. The SUV had a higher one than the pickup trucks that the city had. Mr. Noyes is the paving coordinator, or was the paving coordinator for the Department of Public Works, and what this involves is a lot of travel to, especially during the summer, a lot of travel to construction sites, to paving sites. That's a lot of time in the vehicle. It also involves walking around and doing inspections on those sites of the work being done, usually by third-party contractors. So it is a lot of in and out of the vehicle. It is a lot of time in the vehicle, and it is a lot of time walking around inspecting those job sites. And all of that is reflected in his job description. Mr. Noyes was back for a very short period of time and was re-injured and went back out. His doctor's note requested a leave of at least a few weeks. And ultimately, based on the entire history of Mr. Noyes, the city knew that this would not be a quick return to work because it never had been in the past. The city scheduled a pre-termination hearing, which Mr. Noyes did not provide any evidence that he would be able to return to work in any reasonable time frame, and he was ultimately terminated. Beyond that, Mr. Noyes followed the grievance process, which the city has. During that grievance process, he again, and this was months after his termination date, Mr. Noyes admitted that he still was not able to return to work, would not be able to return to work, even if he had been reinstated at that time through the grievance process. He also expressed that he wasn't sure he wanted to return to work. And when the then director of HR had a conversation with him, he also could not identify any other position that he could or would be willing to perform in the city. Mr. Noyes has made several claims in connection with this, with his termination. And as I sort of following the decision that the investigator made, the first one was the failure to provide him a pickup truck as a reasonable accommodation. In order for an accommodation to be reasonable and to be required, there are a few things that need to be shown. Number one, the request has to be specific enough to allow the city to act on it. The city at this point had a doctor's note clearing him completely for work, received no additional medical documentation from Mr. Noyes, allowing the city to evaluate the nature of his request. And so the city provided him with what it thought was a reasonable accommodation of simply a larger vehicle. Number two, for an accommodation request to be reasonable, it has to be likely to be effective in allowing the employee to perform the essential functions of his job. And there's no evidence in the record that providing Mr. Noyes a pickup truck would have been effective and would have allowed him to continue doing his work without further injury. As I mentioned, the city did measure, went out and it measured the dimensions of the SUV versus the pickup trucks that the city has in its fleet. And it found that the SUV measurements were actually more favorable based on the information that Mr. Noyes subsequently provided about why he thought he needed this accommodation. The investigator found that Mr. Noyes had demonstrated that a pickup truck would have been a reasonable accommodation and allowed him to perform the essential functions of his job based off of Mr. Noyes's sort of throwaway statements that he had not re-injured himself using his own pickup truck. First of all, that's Mr. Noyes didn't request to use his pickup truck on the job. And the dimensions of his pickup truck may very well be different than the pickup truck that the city has. Number two, Mr. Noyes's experience before returning to work was definitely not at the level that it was when he returned to work. He, prior to returning to work, was on leave and presumably using his truck in the way that many of us would use when we are on leave and not actively working. In other words, we're not using our vehicles 8 hours a day, getting in and out numerous times a day. Additionally, the evidence in the record does show that Mr. Noyes actively avoided getting in and out of his pickup truck when he was on leave. When he would come to the DPW office to complete paperwork or similar, get information, things like that, he would actually ask the HR liaison for the department to come out to him rather than him exiting his vehicle and entering the building. So there's nothing in the record showing that a pickup truck would actually have been sufficient to accommodate Mr. Noyes had the city actually given that to him. Moving on to the claim of retaliation, I'll be honest, I don't completely understand the decision that found retaliation but not discrimination for terminating him. The argument appears to be that the city discriminated against Mr. Noyes for requesting yet another leave of absence when he went back out in the fall. But the reality is that he could not perform the essential functions of his job when he went back out. In fact, he still couldn't perform the essential functions of his job many months later during the grievance process. Based on 5+ years of history, it was also reasonable for the city to understand that that leave would drag on for possibly an indefinite amount of time. There is a line in the investigator's decision where they distinguish between indeterminate and indefinite, but the case law does not support any such distinction. I can, if it's helpful, take you through the amount of leave that Mr. Noyes had been provided previously and how that had continually dragged on for many months each time. And so Mr. Noyes was not terminated for retaliation for asking for yet more leave. He was terminated because he could not perform the essential functions of his position. He had only been back in his position a little over a month before he went back out. And so it also is not reasonable to believe that he would be able to perform the essential functions of his position when he returned. So the respondent alleges that there was no retaliation there. He was simply terminated based on his inability to perform the essential functions of his job. And interestingly,
Ms. Torgrosa, I'm sorry, that's your time.
Thank you.
Any commissioner questions for Ms. Torgrosa? Commissioner David and then Commissioner Ashby.
Yes, Attorney Torgrosa, do I understand you to say that the provision of the SUV was a response to a request for an accommodation because of his disability, and that they thought that that was would do the job because they thought its dimensions were better? Is that correct?
Yes, the city interpreted the request for accommodation to be a larger vehicle. So
And then-
provided,
Then they went and they measured it after he protested against it, and they found that it was a lie. I mean, it sounds like a misunderstanding as to what dimension is snagging his leg when he gets in or whatever it is. But the city thought it was doing the right thing, went out and measured it and said, that seems to be the right thing. What was his response to that?
so the measurement came up in the context of the grievance hearing ultimately, which is the only point at which it became clear why Mr. Noyes was requesting the pickup truck. And the former HR director's decision on the grievance is in the record, and it explains how Mr. Noyes was essentially unresponsive and uncooperative in that conversation at that point. And there was no explanation given as to why he thought the pickup truck was necessary over the larger SUV.
There was no explanation, no challenge of that.
No,
Seems significant. It's significant to you in your argument, is it not?
absolutely.
Yeah. Thank you.
Commissioner Ashby, did you have a question?
I did. I'm not sure how to ask it. I think I share some of your confusion about the claim that the termination was a result of a denial of reasonable accommodation, but I think I understand it in that we see traditionally the case where a person is denied a reasonable accommodation, then they bring a claim, or they're denied a reasonable accommodation and they have to leave employment themselves. They aren't terminated. In this case, we have a termination, and I think that's the finding of the investigator, at least, is that the termination was a direct result of the requested accommodation. I think that's how I interpret this investigator's report. I'm not sure if I agree with it or not, but that's how I interpret it. So, but my question to you is, it is the case that our statute does say that leaves of absence can be a reasonable accommodation. You agree with that, right?
I do, yes.
And is it simply a matter of reasonableness? Like, I mean, we have FMLA for a reason, societally, and when FMLA is over, is it always a reasonable accommodation to extend the leave time? Or, I mean, I guess I'm wrestling with sort of what's reasonable and what's not.
I think this is one of the most tricky questions when talking about leave. How much is reasonable and under what circumstances is reasonable? And I think additional, excuse me, additional leave in this situation was unreasonable, given the extensive history of leave, additional leave as an accommodation well beyond FMLA entitlement that Mr. Noyes had been provided over the years, and the experience with Mr. Noyes' leave, where it would be for a period of time and then it would get extended and extended and extended. And even Mr. Noyes' doctor's note taking him out at that point was not phrased in terms of a time frame. It said at least 3 weeks. And I think leave is an unreasonable accommodation when there is no reasonable belief that the employee will be able to return successfully within a reasonable amount of time. And that was the situation here. And that is also how reality played out. Even months later, by Mr. Noyes' own admission, he was still unable to return to work.
Do you think an argument can be made that the FMLA and Maine's codification of it has baked into it a sort of argument that 12 weeks is a reasonable amount of time?
I think that would make employers' jobs much easier if that was the end of reasonableness.
Thank you.
Any other commissioner questions for Ms. Torregrossa? I see you, Commissioner David. Just 1 second. I want to give someone else a chance if they have any. Not
Indeed.
seeing any. Yes, Commissioner David, go ahead.
Attorney Torregrossa, is it the case that the record reflects that Mr. Noyes' condition is progressively getting worse? That his condition is making it more and more difficult to get in and out of vehicles, or making him more prone to injuring his leg? Is it getting worse from the initial accommodation?
So to be clear, the initial accommodation, was 5+ years prior.
That's what I mean. Yeah.
And yes, I do agree. The leaves were becoming significantly longer and more frequent, with shorter periods of time of him being able to work over that period. Yes, I agree with that.
Is the doctor's notes reflect that or not? They just say that he needs time.
The doctor's notes just continued to say that he needed X amount more time before he returned. And then when he went back out, it just said he would need at least 3 weeks.
The thing I'm struggling with is that if a medical condition, a disability is progressing or becoming worse, there comes a time when you can't accommodate it, and we don't know when that is, right?
I agree.
Any other commissioner questions for Ms. Torregrossa? Seeing none. Thank you, Ms. Torregrossa. Then we turn to Mr. Schmitz.
Thank you. Okay, so there are a few things that I'd like to clarify. I think the investigator's report speaks for itself and accurately captures the important facts of this case, but it seems to be there's a little bit of confusion about the facts, so I'd like to touch on a couple of things. I should also say that, good morning, my name is Ryan Schmitz. I'm here on behalf of complainant Kevin Noyes. So first, I think this is actually a pretty straightforward case, and the essential facts are that the city of Portland discriminated against Mr. Noyes on the basis of his disability, and that's not really in dispute. And so when Mr. Noyes came to the city in September of 2019 with a request for a reasonable accommodation, he was ignored. Okay. When the predictable results of continuing his job duties without any accommodation came to pass, and Mr. Noyes needed medical leave to heal, the city promptly fired him. That's not in dispute. That was the basis of the last 10 minutes of conversation. So Mr. Noyes has type 1 diabetes, and he began to experience complications with that disability, which required him to take leave under the FMLA. And that began on December 31st of 2018. So we're talking about 5 years in the past. And, Commissioner David, I think your question kind of centered on this. Taking medical leave due to complications with his type 1 diabetes, that the beginning of the inquiry there, that's December 31st, 2018. Now in February 2019, Mr. Noyes underwent surgery to amputate part of his leg. That is the situation which required the extension of the medical leave and the taking of disability related leave so that he could recover. So, you know, if you're asking if there's evidence that his condition regarding his leg or like the amputation was worsening due to some sort of like progressing medical situation, that's not the case. Not the case, not the situation here. So as part of his recovery, he needs to relearn how to walk, things like that, which takes several months. So when he was asked to return to work, in the kind of process of that, Mr. Noyce was told by a city administrator that he could not return to work until he was, quote, 100%. Now, the city's contention that Mr. Noyce was never told he could not return to work until he was 100% is simply not true. Mr. Noyce had worked for the city for nearly 3 decades at that point and had a years-long working relationship with the city administrator with whom he spoke nearly every day. He was in communication with this administrator throughout his leave, and as part of those discussions, he was told that he could not return to work until his leg had been fully healed, leg wounds fully healed. So I want to talk about the interactive process breaking down for a second. So now Mr. Noyce returned to work on October 7th of 2019, and that day he submitted a reasonable accommodation request form along with a doctor's note. Now the city was talking about how they need, you know, the reasonable accommodation request needs to be specific. He requested the type of vehicle with a doctor's note supporting his request for an accommodation. I don't know how much more specific you need to get, especially, you know, maybe if the city had, you know, engaged in the interactive process and like, you know, met with him and discussed this issue, then maybe he could have been a little bit more specific, but that's not what happened. The city ignored his accommodation request as reflected in the investigator's report, and nothing was done. He assumed he got the SUV and that he was assigned already. There's nothing in the record that suggests that the SUV was an accommodation, by the way. The man is assigned as part of his job a vehicle from the city because so much of his job is working in a vehicle. I'd also like to make a point and really emphasize, because it did come up and also a basis of, I think, one of your questions, Commissioner David, the measurement of the SUV versus the pickup truck. That was not done immediately following Mr. Noyce's a reasonable accommodation request, or to that matter, at any point during while he was still employed with the city. That was after acquired evidence. And for what it's worth, the specifics regarding the actual measurements of the pickup truck, I would dispute when those specific, you know, when those specs were actually taken. I mean, as late in this process as the respondents' Maine Human Rights, you know, Commission response to our complaint, it just said that the measurement, their response just said, without actual real specifics, that the measurements were similar. So, you know, like if we're talking about, you know, the city sitting down and giving him a detailed explanation of why the SUV would actually be better for his leg than the pickup truck, that just simply didn't happen. There's nothing in the record that suggests that. And in fact, the record makes very clear that that is not what happened here. So, like I said, all Mr. Noyce wanted was a pickup truck. The pickup truck height and seat layout made it easier for Mr. Noyce to enter and exit the truck without bending his leg more than 90 degrees at the knee, which, if done repeatedly, risked reopening his surgical wounds. The seat layout would also help him avoid putting too much pressure on the point of contact between his leg and prosthesis while driving. So the way it works is, I mean, he doesn't have an ankle joint or foot. So, you know, all of the pressure that is applied when pressing the brake or pressing the, you know, the accelerator, that's all done on the pressure point. That's all of that is focused on the pressure point between his leg and his prosthetic. And now that, you know, because of repeatedly doing that in a space while also getting in and out of a truck in a space that is not well accommodating to his prosthesis, that's what caused his leg wounds to reopen. And that's what caused him to require additional leave, something that he knew, which is why he requested the pickup truck in the first place. Now, his accommodation, again, was completely ignored. The city did not respond. So the city somehow blames Mr. Noyce for the breakdown in the interactive process following his request. It is undisputed that the city didn't respond. And further in its filings, the city repeatedly admits, quote, regardless of the medical need for accommodation, the city thought it was accommodating Mr. Noyce by providing him an SUV for his job. Now, the investigator's report is correct in its assessment that the city failed to engage in the interactive process there. So it admits that it stopped. It stopped the interactive process. So Like I said, Mr. Noyce was painfully aware that even small derivations in legroom and seat height, particularly the ability to adjust his seat, are critical in one's leg position while driving. Now, like I said, he pushes from the hip. That's a lot of pressure to put on the meeting between his leg and the prosthesis. And now the city had also talked about measurements between ground and floor of the truck. But really the more important measurement here is ground and seat. Mr. Noyce has to lift himself onto his seat and then adjust and then slide his legs in without bending it to the extent that he can. That's the really important thing. It's not about how tall the truck is off the ground, it's how tall the seat is off the ground. But that isn't the only measurement here. I mean, there's a lot of like small derivations that can make a really big difference. So just for an example, the difference in factory specs for a city-owned Ford Escape versus a pickup truck that Mr. Noyce owns and operates illustrates how only a couple of inches of clearance makes a vehicle accessible. So the Ford SUV has a 42.4 inch of inches of legroom versus 44.5 inches in Mr. Noyce's pickup truck. That's barely a difference of just over 2 inches. And it's very, very significant when considering how much deeper Mr. Noyce had to bend his knee in the SUV. And when you're trying to avoid your skin rubbing and pinching against the edge of your prosthesis, an extra inch of legroom means less pressure on sensitive skin. Despite the city's refusal to engage in the interactive process, Mr. Noyce was successfully performing his job in the weeks immediately following his reinstatement, which both the investigators' report reflects and was discussed during the issues and resolution conference that was freely admitted by the city. And it's a really important point. Mr. Noyce has been a 30-year employee of the city, has risen the ranks, and is an incredibly dedicated and hard worker for the city. And now the city has come and talked about how he's not capable of doing the job. It's frankly offensive, and it's just not fair to treat a city worker like that. So again, I would just really like to reemphasize here that Mr. Noyce has, since being terminated from his position, driven his pickup truck quite a bit. He spends a lot of his time in his car and has never had an issue with reopening his legroom. The only factor that has changed in the period leading up to and then following his wounds reopening was that he was forced to drive this SUV. That is the only difference. So I just want to touch on retaliation very quickly. And the city's failure to provide a pickup truck as a reasonable accommodation predictably led to his wounds reopening, which necessitated additional leave. When Mr. Noyce notified the city that he would need to take another 3 or more weeks of leave to heal so he could return to work, the city refused to allow him to take that leave and terminated him. Like you just heard, the city admits his termination was because he requested leave on top of leave. Contrary to the city's framing, Mr. Noyce did not request indefinite leave. The doctor's note stated that he would need, quote, at least 3 weeks of leave. Okay, that is not indefinite. That is a specific amount of time. If you need a little bit more time than that, that's one thing. But to say that Mr. Noyce just had like requested leave and then walked away from the table, it's just not the correct framing here. And as for what it's worth, the First Circuit has held that even after an employee has taken a year or more of medical leave, a request for additional medical leave can be a reasonable accommodation, and the burden is on the city to show that the additional leave would have been an undue hardship. And has even attempted to make that shown. Rather, the city admits that when they got the additional request for leave, they saw the note and decided, no, we're done. They washed their hands.
Sorry, that's your time. Thank you. Commissioner questions. I see Commissioner Whitworth and then Commissioner Ashby.
So I just want to make sure I haven't missed something. It says here that complainant on September 26, 2019, complainant was cleared to work on October 7th with no restrictions. So with no restrictions, I interpret that as no restrictions. So if he, in fact, needed a truck rather than an SUV, wouldn't that have been written in the notes relative to restrictions, such as he can come back to work as long as he has a truck? Am I reading this wrong? Maybe I'm interpreting the regulations inappropriately, but that's how I typically interpret things. So please educate me if I'm mistaken.
Absolutely. So I think he was clear to return to work, but the important thing is here that he returned to work. On the day he returned to work, he requested an accommodation with the supportive doctor's note. Now that is not, working without restraint. He's came to work. He said he needed the accommodation, and he got it with support from the physician, the same physician that cleared him to return to work. And it's not like when he came to work with the reasonable accommodation, the city said, well, wait a minute, but you said you couldn't return to. There was no discussion. It was ignored. There was a breakdown in the interactive process at that point. So the restrictions were, it's not like he couldn't perform the essential functions of his job. He just needed this accommodation to perform that work. I wouldn't call that necessarily a restriction. He just required an accommodation. He was able to perform, and as the city admits, performed the essential functions of his job perfectly well. It's just that when the results of the lack of accommodation inevitably showed themselves, that's why we find ourselves here.
Barbara, can I ask that question of you, please? If somebody is coming back to work with no restrictions and then has a request for something, does that fall in line with the regulations? Or are no restrictions? I just need some clarification.
Sure. I think that part of this is a discussion, is an interpretation of what no restrictions means, but also the fact that the doctor cleared him with no restrictions. The doctor also supported his request for the accommodation of the truck. So what the law requires is for him to be able to work with or without reasonable accommodations, and he requested the truck as a reasonable accommodation. I don't think it's necessarily inconsistent with a statement that he can work without restrictions, which are typically things like lifting or hours or things like that.
Thank you.
Commissioner Whitworth, you're all set? Okay. Commissioner Ashby?
Yes, thank you. So the investigator's report indicates that the complainant requested the city provide him with a pickup truck rather than an SUV. On his initial accommodation paperwork, he indicated the reason he needed the pickup truck was because of his prosthetic legs. Do you remember the language used in the actual doctor's report about that? I mean, was there any more specificity than that?
I don't have the language from the doctor's note actually memorized. I apologize for that, but I will say that that's not that level of specificity certainly isn't required to at least trigger the interactive process here, which is where this broke down. So while I unfortunately don't have the exact language off the top of my head, I will say the fact that there was any language at all and a specific enough request that there was a tangible accommodation that the city could have provided and had the means to provide. I think that's the more important thing here.
Well, yes, but in the respondent's appeal, in their response, they say the city did in fact ask for additional information. It provided complainant the medical form necessary to justify a reasonable accommodation request and asked him to have his provider complete that form and return it to the city. And at least in the response, it suggested that the complainant didn't take that step. Do you agree that that happened or didn't happen?
No, I don't agree that that happened. I think we've been very clear from the start, and the record certainly reflects this, as does the investigator's report, that the interactive process broke down at the request of accommodation. The city ignored it. And in fact, there's evidence in the record that suggests that during the pre-termination hearing, when he talked about the accommodation request, there were individuals involved with Mr. Noyce's termination that didn't know about the accommodation request at all, that it was a complete surprise to them. So the idea that the city somehow did actually engage in the interactive process, I think is contrary to the evidence of the record, and it's certainly contrary to the findings in the investigator's report.
It's so, I mean, I guess we can ask both the investigator and the respondent's counsel will have a chance to.
Well, Commissioner Ashby, I don't want to interrupt you, but I have heard in messages from both respondent's counsel and from the investigator that they both want to be clear that there was no doctor's note submitted with the request for accommodation.
Okay. Okay, thank you for that. And the suggestion that there was a medical form given to complainant to fill out is so fact specific. Are you saying that's just whole cloth, Attorney Schmitz? I mean, that just never happened? No form was given to the complainant?
There's no evidence in the record. I mean, the findings in the investigator's report back this up, that there was no interactive process that occurred after complainant submitted his reasonable accommodation form. I mean,
Okay.
I
We'll have
welcome
to we can explore that with the investigator. Regardless of whether a form was given to the complainant or not, after he utilized the SUV as opposed to a pickup truck for some period of time and it became apparent that his wounds were being affected by that, did he ever, does the record show that he ever approached the city and said, hey, look, this SUV thing isn't working out. I need a pickup truck. I know I said it, when I came back to work, I got the SUV. I got this problem now. Can you hook me up with a pickup truck? See, this problem is happening. Did that happen? Anything like that happen?
No. I think the complainant understood the city's silence on his accommodation request as a denial and just, didn't follow up on it because he had felt that he was shut down by the city. And it's not like there was a long period of time before the results, showed themselves. It was roughly 3 weeks from the date of his beginning to the date that he requested medical leave again, that his wounds reopened. So,
well, as Commissioner David's question suggested, what if this is just a case of a misunderstanding that the city believed it accommodated the complainant and it didn't end up being an accommodation that worked out for the complainant? What if this is just a misunderstanding? We simply left then with the argument that, well, okay, but the additional leave was also an accommodation request, and that the termination that resulted thereon is the centerpiece of the complainant's case. Is that sort of a theory B in this case?
No, I don't think so, because I think the essential aspect of this is that there was no interactive process, which is the respondent's duty under federal and state disability law, is that their accommodation was requested, no interactive process came from that, and the complainant was forced to take disability leave because of the predictable results of not getting his accommodation. I don't think that this is a misunderstanding at all. There's just simply it was a plain violation of federal and state disability law. And the reasonable accommodation was denied. And then when he followed up and requested additional leave as an accommodation, he was terminated. I think it's pretty cut and dry. I don't really think there is a theory B here.
Well, if there is, would you agree that the strongest argument you have is that the city didn't explore the reasonableness of a request for at least 3 weeks additional leave?
The city didn't explore the reasonableness of any of his requests. It didn't explore the reasonableness of his request for a pickup truck, and then it didn't explore the reasonableness of his request for leave. I mean, there was a period in the doctor's note requesting leave. No leave was granted. When the leave was requested, there was a termination. So yes, I think that's absolutely a part of this, is that the city just saw the word leave request and said, we're done. That is certainly strong evidence in our favor. Yeah, I agree with that.
Great, thank you.
Thank you.
Any additional commissioner questions for Mr. Schmitz? Not. So Commissioner Whitworth?
Sorry, I just found something that I had highlighted. Was there any time when the city considered the maybe purchase or assignment of a pickup truck to be an undue hardship, equating to financial or administrative hardship? Maybe that's a question I need to ask the attorney for the city.
I could actually answer that. No, first of all, the city hasn't asserted that anywhere. And in fact, this was discussed at the Issues and Resolution Conference. A subordinate immediately under Mr. Noyce was assigned like a brand new pickup truck right around the time that he returned to his work. So absolutely, there's no evidence to support that there is some sort of undue hardship or financial burden. Thank you.
Any other commissioner questions for Mr. Schmitz? Not seeing any. Thank you, Mr. Schmitz. And now we will turn to the investigator, to Alex Brindley.
Hello and good morning, commissioners, everybody. My name is Alex Brindley. I was the investigator assigned to this case. So what I want to do first is just run through my analysis of how I got to my conclusion for the reasonable accommodation request, because there seemed to be a couple questions surrounding that. So first, when complainant first made the request for reasonable accommodation, just like Amy said previously, there was no doctor's note to support that. However, I didn't find that to be the crux of the issue. The crux of the issue that I found was the fact that when complainant made the request, he indicated that he needed the pickup truck with the reasoning of his prosthetic legs. He also provided information to his his physician contact information. What then happened later was that the city did not interact further after receiving that request. They didn't follow up with any information. They didn't talk to his doctor, even though that's not exactly necessary. And I do want to note that, it's not legally required to have a medical form filled out for a reasonable accommodation request. So for me, it was just the fact that after receiving this request for the pickup truck, stating that the reason needed was his prosthetic legs, and the fact that the city wasn't in any communication with the complainant in that fact, that led me to believe that the city did not engage in the interactive process for that request. And then for the leave request, it's my understanding that each leave request should be assessed independently. So in order to determine its reasonableness, you need to determine whether it's reasonable to for him to take 3 weeks leave, which, I think most employers would agree that 3 weeks leave is totally acceptable. And as Attorney Schmitz stated previously, at no time did the city indicate that his leave request or the pickup request was an undue hardship. So they just provided that it was unreasonable. But I believe, according to the facts presented in the record, that the request for the pickup truck and also for 3 weeks additional leave in order to heal from his injuries, whether or not they were sustained from the pickup truck or the SUV or not, was in fact reasonable. And there was no indication that he couldn't perform the essential functions of his job, because before he went out on his final leave, or rather when he made his final request for leave, he was performing the essential functions of his job as indicated by the respondent representative in the Issues and Resolutions Conference. And it was stated previously, I believe, in Attorney Torregrosa's presentation that the complainant admitted that he was unable to perform the essential functions in a later meeting with the city. But during the IRC, the complainant blatantly denied stating that he was not able to perform the essential functions of his job. But I think, sorry, that was a lot. I think that's all that I have for the reasonable accommodation, but I can talk about it more, and I'm always open to any questions, so feel free.
Thank you, Alex. Commissioner Whitworth?
So the record here says on October 29th, 2019, the doctor's note stating, Kevin Noyes is currently under our care for a serious issue. We advise no work for at least the next 3 weeks.
Certainly.
It does not say the next 3 weeks. It says for at least the next 3 weeks.
Certainly. And that's kind of how I came up with the term indeterminate, not indefinite. I had conversations with a lot of my coworkers about this fact. But I mean, from what I can gather and what I've discussed with my coworkers is that at least 3 weeks is at the very least a minimum of 3 weeks with potential for more. However, it didn't say at any time until further notice the complainant was unable to return to work. And he had always returned to work when his previous leave, whether or not they were extended or not, he had always returned back to work, and there was no indication that he would be unable to return to work after his injuries healed.
Commissioner Whitworth, did you have?
Thank you. Thank you. Sorry, on mute.
Commissioner Ashby?
Yes, hi. Yeah, I certainly agree that the respondent is not required to inquire further or send forms to the physician in the event that a reasonable accommodation request is made, but there is this big factual dispute that I think I want your help resolving, and that is, did in fact the respondent, upon receipt of this request of the complainant, did the respondent give him a medical form necessary for the doctor to fill out to explain the basis for the request?
So that's a good question. From what I've read of the record, and I reviewed it just this morning, I believe the medical documentation form was included in the request for reasonable accommodation form that the complainant filled out. I just believe that the complainant did not fill out the medical form when providing his request for reasonable accommodation. So I believe it was the same packet.
Thanks.
Commissioner David?
Good morning, Alex. In the same vein as Commissioner Ashby, I think, am I hearing that he makes a request for an accommodation and your conclusion is that just nothing happens? Is this, and is that conclusion because it's discriminatory animus, or is it bureaucratic oversight? I mean, where does the request go? Does he follow up saying, hey, what's happening with my request? I can imagine the city is big enough so it has, the departmental bureaucratic procedures for it. It just gets lost, and we assume that there's no, Attorney Schmidt says repeatedly, there's no interactive process, there's no interactive process. Why not? Does anybody ask?
Commissioner David, from what I understand of the law, there is no discriminatory animus needed for denial of reasonable accommodation. So really, for me, at least, based on the record and the law, the city did not follow through with after receiving the request for reasonable accommodation. Certainly, the city provided an SUV for complainants, and the city later provided that they believed that was sufficient. However, I don't think there's anything in the record, at least, to indicate that that was provided as a reasonable accommodation.
The provision of the SUV is after the accommodation request, right?
Correct. He was provided the SUV after he requested the accommodation, because he requested it immediately after.
Was that his first vehicle? I mean, did he ever have a pickup truck? Did he ever?
He did not have a pickup truck in the past, no. But I don't remember off the top of my head if it was indicated in the record what his previous vehicle was.
Thank you.
Mm-hmm.
Commissioner Whitworth?
Follow-up question. So respondent has said that complainant returned to work. This is in contrary to what has been said. Complainant returned to work on October 7th and worked 3 weeks before he requested to go out on indefinite medical leave. Since complainant was unable to return to work, respondent had to terminate complainant's employment. Is that true or not true? That's in contradiction to respondent. We advise no work for at least the next 3 weeks. So is it 3 weeks or indefinite? There's contrary.
It was, my apologies.
No, go ahead.
Okay. So the language was at least the next 3 weeks. So that's why I believe it was indeterminate as opposed to indefinite request for leave. The city certainly interpreted it as a request for indefinite leave.
But he did request to go out on indefinite medical leave?
He did not. He made the request to go out on at least 3 weeks of leave.
Okay, thank you.
Mm-hmm.
Commissioner David, did you have a follow-up?
Yes, yes, I did. Completely different topic. Looking at the recommendations, can you explain to me where the difference is between Maine Human Rights and WPA. Nobody's addressed that in their presentation.
Well, in this case, there was no allegation of WPA retaliation. So just generally, or actually, here it is. Sorry, it's been a while. It's been a weekend. For a claim of WPA retaliation, there needs to be a report of conduct that the complainant believes is illegal and or unsafe. And I don't
Okay,
think that
I've got that, and there's been no reports of unsafe stuff.
Mhm.
So that's the recommendation on WPA.
Right.
But that there's retaliation from Maine Human Rights. Remind me where that conclusion comes from.
the retaliation claim.
Yeah.
So based on the record, so what happened here is the complainant made his final request. He made a request for at least 3 weeks of leave. And then he was fired in short order after that. And let's see, if we go through the prima facie case, the complainant engaged in the activity protected, i.e. his request for leave. He was a subject of adverse employment action, i.e. he was terminated, his employment was terminated. And lastly, there was a causal link between the protected activity and the adverse action, which may be proven by close proximity between them. So the close proximity in this case is the fact that his request for leave and the fact that he was fired happened in a very short amount of time.
Okay. And so what you're telling me is that the request for leave is a protected activity and that he was fired because he requested it?
Correct. That is the retaliation claim that I have written.
Okay.
Commissioner Ashby?
Related to that, the complainant has argued that there was no sort of interactive consideration on the part of the city with respect to that requested leave. I see, of course, that they did write a November 6, 2019 response, a written response to indicate that the reasoning, their rationale, the fact that he had exhausted all of his FMLA and they were not willing to extend the leave. I mean, I guess the argument, if the argument is that the violation of the law came when they failed to engage in an interactive process, what would that interactive process what could that have looked like? I mean, if their view is, look, we just can't give you any more time, and it's not reasonable for you to ask it. What other additional sort of interaction do you think would be required to make this sort of pass muster?
So I do want to state that his request for reasonable accommodation and his discharge claim are two entirely separate analysis. So the discharge claim is dependent on the retaliation for making the reasonable accommodation request. But yeah, certainly the respondent did send the complainant a letter stating that, you know, this is the reason that we can't accommodate you. And as such, we are terminating your employment. However, my apologies. I think your question got lost in the weeds. Could you repeat yourself?
I think you started to answer. I guess I want to take issue with the suggestion that the two aren't related. I mean, the complainant didn't have the alternative at that moment to say, okay, well then I'll just keep on working, right? I mean, obviously he couldn't. He actually couldn't continue to work. So your suggestion is that the termination occurred because he asked for the leave time.
Correct.
Really well, okay. I guess that's open to interpretation. All right. I think I'm all set, Alex. Thank you.
Okay, thank you.
Any other commissioner questions for the investigator? Seeing none. Thank you, Alex.
Thank you.
So commissioners, you've heard from the parties through their counsel and from the investigator. There are 3 proposed findings. It might make sense to take them separately.
Yeah, I'll take the third recommendation first. I move that there are no reasonable grounds to believe that the respondent discharged the complainant because he's an individual with disability or retaliated against him for engaging in WPA protected activity, and those claims should be dismissed in accordance with the act.
I'll second, and I think Commissioner Ashby is taking the low hanging fruit first.
I am.
I think I heard Commissioner O'Brien first as the second there.
Oh, okay.
So it's been moved and seconded on the third proposed finding. Is there any discussion on that one? Seeing none. So the motion is to find no reasonable grounds to believe that respondent discharged complainant because he's an individual with a disability or retaliated for whistleblower activity. If you say yes, you are in agreement with that finding. Commissioner Whitworth,
Yes.
Commissioner Ashby,
Yes.
Commissioner David,
Yes.
Commissioner O'Brien.
Yes.
Okay, that one is no reasonable grounds.
And I will move, with all the respect to our investigator, I'll move that we reject the findings of the investigator and find that there are no reasonable grounds to believe that the respondent discriminated against the complainant on the basis of disability, denial of reasonable accommodation, and that there are no reasonable grounds to believe that the respondent retaliated against the complainant for engaging in MHRA protected activity, and that the claims be dismissed.
Second.
So it's been moved and seconded to find no reasonable grounds to believe that respondent discriminated against complainant on the basis of disability for reasonable accommodation, and also no reasonable grounds to believe that respondent retaliated against complainant for MHRA activity. Is there any discussion among commissioners? Yeah, go ahead.
Just very briefly, I guess I'm not inclined to believe that there is an actionable denial of an accommodation based on the request for the pickup truck. And so I do think that the best sort of claim that the complainant has is the denial of the requested leave. I don't know what sort of interactive discussion could have occurred. I do think the law requires that the respondent has an obligation to seriously consider requests for an accommodation like extended leave. But the history of this case shows that and the amount of time taken by the complainant thus far, it's reasonable to deny that request in light of the fact that he had exhausted all of his FMLA and some disability leave. And that they did in fact articulate that in the November 6, 2019 letter to him. And I think that probably is enough. I don't think probably, I'm certain that that's enough to shield the respondent from a claim of denial of reasonable accommodation. And relatedly, because I think they are very related, the termination for having made that request. I don't think the termination was for having made the request.
I concur. The key, it's a tough case looking at it with a short lens of just what happens at the end. But with that history, I don't think that they're committing unlawful discrimination. And I'll support the motion.
Any additional discussion among commissioners? Seeing none. So the motion is to find no reasonable grounds, both for disability discrimination based on denial of reasonable accommodation and no reasonable grounds for MHRA retaliation. If you say yes, you're in agreement to both no reasonable grounds findings. Commissioner Whitworth?
Yes.
Commissioner Ashby?
Yes.
Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
So those findings, so all three findings are no reasonable grounds. And the commission will send parties in council a letter confirming that. And we thank you for your participation and especially for given the delay in your hearing today. So thank you very much to the parties. And that's the end of the hearing agenda.
Amy, do you have any new business?
No, I did that already.
You already did that. Okay.
So at this point, we'd be looking for a motion to go into executive session.
Yes.
That cites the proper parts of the statute.
I can do that. So
Last
pursuant
time, Deb's last time making the motion.
to, well, I'll make the motion, we come out as well if you'd like.
Oh, yeah, thank you.
Pursuant to 1 MRS Section 4056E, I move to go into executive session to consult with our attorney regarding pending and contemplated litigation and the legal rights and duties of the commission.
Second,
It's been moved and seconded. Is there any discussion? I see no discussion. So all in favor, actually, I have to pull you. So the motion is to go into executive session. If you say yes, you're in agreement. Commissioner Whitworth,
Yes.
Commissioner Ashby.
Yes.
Commissioner David,
yes.
Commissioner O'Brien.
Yes.
Okay, great. So theoretically, we're all going to go, not all of us. Investigators, you are not going to come into executive session. The rest of us are going to. So theoretically, I'm going to move you right in there right now. we have 1, 2, 3. We need Julie and Mel.
On the other hand, we seem to have Angela. There's some
Well,
dedication.
Angela's been here all along.
I know.
New investigators, just so you guys know, new investigators are required to watch commission meetings, so they learn the process. Angela is being very dutiful. Good job, Angela. Gonna have to talk to Colin, who clearly misunderstood the instruction. Hopefully Julie's coming back. Do you think she misunderstood?
We've
But we
got
still
a
have
quorum.
Still got a quorum, yep.
Then I'll move, I guess, that we not litigate MHRC case number H220436AB.
Second.
So it's been moved and seconded not to litigate the Kapinga case. Is there any discussion? Seeing none. All those commissioners in favor of the motion, raise your hand and indicate orally. I can do that, right?
Yes. Yes.
Jeff?
Yes.
All right, good. I'll say 3-0 and that Commissioner O'Brien had departed. I think with that, we are done.
Well,
Yeah, just
we're not
before we
done,
leave-
but Deb is.
Before we leave, I just do want to say, Deb, I really have enjoyed working with you. I've learned an awful lot from you. I really value you
Right.
on this board or on the commission, and I don't know, I just really have. It's been a pleasure. I suspect I'll reach out to you someday when I need an expert. So maybe I'll talk to you soon, even. But if not, be well.
I wholeheartedly second that, Deb.
You're muted.
You're muted.
I think by
you're
now,
saying
Deb, you've
touching
learned how to
things.
use Zoom. You know?
All right, very much appreciated. Thank you both. I appreciate it.
We let you go unwillingly, but we will. Commissioner O'Brien, just so you know, we weren't sure if you had departed altogether. So the commissioners did, 3 of the commissioners did just vote not to litigate that case. And that's, I think, all the business we have. So unless anyone has anything else, then I guess that's it.
Thank you all. It's been a pleasure.
Thanks, Deb.
Thank you.
Bye, Deb.
I did.